In Toronto, on October 31, 1926, lawyer Charles Vance Miller died, and his will left the bulk of his fortune, probated at $322,309, to the woman in that same city who gave birth to the most children in the next 10 years. It sounded like a joke. It would take 12 years, from Miller's funeral to the final rulings on who actually qualified, for anyone to find out whether it could stand. The clause was the 10th and largest in the will. The residue, in what was left after every other gift and debt, would sit for 10 years, then go to whichever Toronto mother had produced the most children since Miller's death. A tie split the money equally. That wording turned birth records into legal evidence. A child was not just a child anymore. A child became a date, a status, a record, and eventually an exhibit. Miller was a Toronto lawyer, financier, and practical joker, and by every account, a formidably sharp one. He'd graduated from the University of Toronto with a 98% average across every subject, then passed the bar at Osgoode Hall in 1884. He had not married, he had no descendants. His will called itself necessarily uncommon and capricious, and declared that no duty rests upon me to leave any property at my death. He called what he'd kept proof of my folly in gathering and retaining more than I required in my lifetime. Later accounts describe him leaving money on a sidewalk, then hiding to watch strangers pocket it. Another account has him sleeping on his veranda in every kind of weather, saying it kept him hard. He was never known in life to give to charity. He owned 7 horses. He belonged to exactly one club in his life, the Royal Canadian Yacht Club, nowhere near the racetracks and jockey clubs he kept legislating about in his own will. And he had a strange sort of business reputation. The racetrack owner, Abe Orpin, did deals with him for years, on handshakes, never on paper. Orpin said flatly that he distrusted the man, and that Miller would always go hunting for a loophole in any contract he did sign. And yet, by Orpin's own account, Miller never once broke his word. By another telling, Miller's own theory was simpler still. Every man had his price. To later readers, the will matched the same reputation, whatever he actually meant by it. The birth clause was not his first condition. Clause 6 offered racetrack shares to 3 men, if they enrolled as shareholders within 3 years, 2 temperance and anti-gambling reform figures, and Abe Orpin, a racetrack owner who, by reputation, detested the Ontario Jockey Club. Orpin took the shares anyway. Clause 7 gave a share in a different racetrack to every ordained minister in 3 towns, except one, a minister named Spracklin. He had shot a hotel keeper. Even Miller drew a line somewhere. Clause 8 offered brewery stock to Protestant ministers and Orange lodges who claimed it. Clause 9 was the cruelest of the 4. Miller's Jamaica house, left for the lifetime use of 3 men who, by all accounts, could not stand each other, on the condition that they live there together. All 3, as it happened, were King's Counsel. Lawyers like Miller himself, sentenced to cohabit as the punchline of one of his colleagues' wills. It hardly mattered. The birth clause was not his first condition. Clause 6 offered racetrack shares to 3 men if they enrolled as shareholders within 3 years, 2 temperance and anti-gambling reform figures, and Abe Orpin, a racetrack owner who, by reputation, detested the Ontario Jockey Club. Orpin took the shares anyway. Then Miller's distant relatives moved to have the will thrown out. They took the fight to the Supreme Court of Canada. The residue clause, they argued, was contrary to public policy. If they won, the condition died, and with it, any mother's claim to the money. Their argument, a fortune that size dangled over childbirth, could pressure families into acting against their own interests for money. It could push exhausted women into one more pregnancy, one more year, for a prize that only one of them would ever collect. Public policy, they said, should not let a private will manufacture that kind of incentive, whatever the law usually let a testator do with his own property. Miller's side had an answer built into the will itself. He owed nothing to anyone. No duty rests upon me to leave any property at my death. His words, sworn and probated. Strike the clause, and a court wasn't just voiding an eccentric sentence. It was overriding a dead man's plainly written instruction. and erasing the one path the mothers had to the money. The 10 years didn't sit still. A $2 Miller land investment beside the Detroit-Windsor Tunnel grew past $100,000. The estate swelled through the Depression's deflation. Delay didn't shrink the prize. It made it bigger and harder to look away from for families who had never asked to be part of the arithmetic. On paper, this looked like arithmetic. Count the births, hand over the money. It wasn't that simple. The clause said children, and the court still had to decide whether that word covered children born outside marriage. That legal definition would come first. Any counting would come after. The question was serious enough that the court appointed a lawyer whose entire job was representing mothers whose children's legitimacy was in dispute. A job that existed for exactly one reason. Nobody yet knew who counted. So, does public policy kill the clause, or does testamentary freedom keep it standing? Give me your ruling in the comments. Here's what the court actually found. On December 22, 1937, the Supreme Court of Canada dismissed the appeal. The clause stood, and the appeal on public policy grounds failed. But the win came narrower than it looked. The court also ruled that children under this clause did not include children born outside marriage. 5 judges heard the case: Duff, Crockett, Davis, Kerwin, and Hudson. All 5 agreed the appeal should fail. Not all 5 agreed on why. Justice Crockett signed on to the result and then, in his own separate reasons, refused to sign on to the logic behind it. He warned that the majority's test, proof of harm so obvious it was beyond argument, set the bar absurdly high. As an example, he raised a fortune left to fund a permanent campaign against every church in the country. Would a court really be powerless to touch that, he asked, just because plenty of people might agree with it? He agreed with the result and rejected the reasoning behind it in the same breath. The clause stood 5-0 on at least 2 different legal theories. The Supreme Court settled the rule. The later count under that rule produced 4 winning mothers. Judge William Edward Middleton ruled for Annie Catherine Smith, Kathleen Ellen Nagel, Lucy Alice Timlick, and Isabel Mary McLean. 9 registered children each. Each mother received $110,000. Something like $2.35 million today. That later process wasn't gentle. 11 families had entered. 7 were disqualified. Florence Brown had 26 children in total, but only 6 had been born since Miller's death. 6 wasn't enough. The 4 winners each had 9. Grace Bagnato, who had 20 children in total and 10 surviving, was ruled ineligible in February 1938 because 2 births were unregistered. Lillian Kenny was ruled ineligible over multiple stillbirths and unregistered births of her own. She and another ineligible claimant, Pauline May Clark, whose relationship with a man named Harold Medill, newspapers described in sensational terms as an illicit romance, each accepted $12,500 out of court rather than keep appealing. The chase left real damage behind it. Several competing mothers ended up hospitalized for blood transfusions and surgery from pregnancy after pregnancy during the worst years of the Depression. The final estate, once liquidated, came to roughly $568,106, grown from $322,309 at probate, but the payout didn't arrive clean. 3 of the 4 winning families had to repay Depression-era relief money to the city of Toronto before they could spend a cent of it. The Timlicks put theirs into property and a business instead. Money that started as a joke on a dead man's page had become a mortgage, a debt, and a fresh start, depending on which family opened the envelope. The clause held. Testamentary freedom outlasted the challenge, and 4 families got their money, along with a debt to repay, an investment to make, and a story that outlived the check. Miller was said to have believed that every man had his price. 12 years, 11 families, and 1 Supreme Court later, nothing in the record proved him wrong. Next, Leonard versus PepsiCo, when a joke in an ad met a court that didn't laugh. Subscribe for more.